Have you ever created something inspired by another artist and wondered whether you'd crossed a legal line? Maybe you heard of a song and thought, gee, I love that vibe. Or you've seen a brand or a logo or a website or a social media campaign and thought, I'd like something that really feels like that. The reality is that almost every creative work is influenced by something that came before it. Creativity doesn't happen in a vacuum. But what happens when inspiration starts looking a little too much like imitation? Today we're looking at a pretty controversial copyright case of the modern era. Williams and Gaye, better known as the Blurred Lines case. It's a case that sparked a global debate about whether copyright protects ideas, styles, and feel, the vibe, or only actual expression. And even if you're not a musician, the lessons from this case apply to anyone creating content, brands, products, designs, advertising campaigns, or creative works. Welcome back to Elise Explains IP. I'm Elise Steekstra, your host, intellectual property lawyer, trademarks attorney, and general nerd, and today we're exploring one of the most famous recent copyright disputes and what it teaches us about the difference between inspiration and infringement. Let's rewind the clock to 2013. Robin Thicke, Pharrell Williams, and T.I. released Blurred Lines. The song was an enormous commercial success. It topped charts around the world, it dominated radio, it won awards. It was later accused of some fairly nasty behaviour on set, but that wasn't relevant at the time because it was 2013. And for a period of time, it was almost impossible to avoid. But as the song gained popularity, people began noticing something. It felt familiar. Many listeners commented that it had a very similar groove and atmosphere to Marvin Gaye's 1977 classic, Gotta Give It Up. Importantly, nobody was claiming that the lyrics were copied. Nobody was pointing to identical melodies. Nobody was suggesting that there had been a direct sample of Marvin Gaye's recording. Instead, people were saying something more subjective. It sounds like Marvin Gaye. That observation would ultimately lead to one of the most significant copyright lawsuits in modern music history. The heirs of Marvin Gaye argued that Blurred Lines infringed copyright in Got to Give It Up. Robin Thicke and Pharrell Williams denied the infringement. In fact, they initially took the unusual step of filing proceedings seeking a declaration that Blurred Lines did not infringe the earlier work. The dispute eventually went before a jury in the United States. The central question was deceptively simple. Had the creators of Blurred Lines copied protectable elements of Marvin Gaye's composition? Or had they merely drawn inspiration from the style and atmosphere of an earlier song? So, what is the problem here? One of the reasons the case became so controversial is that copyright law generally does not protect broad ideas, concepts, genres, or artistic styles. You can't own jazz, for example. Taylor Swift doesn't own country music. The Bee Gees do not own disco. You can't own the idea of a funky bass line. You can't own a retro aesthetic. If copyright protected styles, entire creative industries would grind to a halt. Every artist builds on what came before. Every creative movement influences future creators. Copyright instead protects the specific expression of ideas, and that's where the legal challenge emerged. The Gaye estate argued that this wasn't merely about style. They argued that enough of the specific elements had been copied that the similarities crossed the line from inspiration into infringement. The case involved extensive musicological evidence, because of course it did. Experts analysed the songs in extraordinary detail. The similarities discussed included the musical phrases, bass movement, keyboard parts, percussion patterns, structural features, and overall arrangement. Individually, many of these elements are relatively common, but the argument was that when combined, they created a distinct pattern of expression that had been appropriated. This is where things became complicated. Many musicians and copyright lawyers worried that the case was drifting dangerously close to protecting a musical feel. And if copyright protects a feel or a vibe, Where does that leave future creativity? So, what did the jury decide? In 2015, the jury found in favour of Marvin Gaye's estate. The verdict resulted in millions of dollars in damages and a profit sharing with Pharrell Williams and Robin Thicke. The decision was later upheld in significant respects upon appeal. The outcome shocked many commentators. Some celebrated the decision as a victory for creators. Others viewed it as a dangerous expansion of the copyright protection that is generally accepted under law, and the debate continues today. So why was the decision so controversial? The criticism wasn't necessarily about whether blurred lines had been influenced by Marvin Gaye. Even Pharrell Williams acknowledged that the song was inspired by the era and the sound associated with Gaye's music. The concern was something broader. Many musicians asked, if sounding influenced by another artist can create liability, how can anyone safely create music? After all, rock music builds on earlier rock music. Jazz musicians borrow traditions from previous generations. Hip-hop constantly references and reinterprets earlier works. Pop music evolves through influence and through trends and adaptations. Influence is part of creativity. Without influence, innovation becomes impossible. This led some commentators to argue that the case blurred the distinction between copying expression and drawing inspiration from style. Ironically, a case about blurred lines created blurred lines in copyright law itself. Would this result happen in Australia? So this is where things become particularly interesting. In Australia, copyright law approaches infringement somewhat differently to some other parts of the world. Australian courts generally focus on whether a substantial part of the original work has been reproduced, but importantly, substantial refers more to the quality than the quantity. It's not about how much of the work was taken, but how significant that work that was taken is to the original work. A relatively small portion of a work may be substantial if it represents an important or distinctive part of the original. Australian courts typically look for evidence that protectable expression has actually been reproduced. Simply creating something with a similar mood, style, or vibe would generally not be enough. That doesn't mean a similar claim couldn't succeed in Australia. But Australian courts would likely focus closely on identifying the actual copyright material that was allegedly copied. Remind me to come back and talk to you about Men at Work and the flute song from Kookaburra Sits in the Old Gum Tree, because that's a whole doozy. You don't need to be writing chart-topping songs for this case to matter. The same principles rise every day in business. Consider these examples. A business owner says to you, I want my website to feel like apples. That's probably okay. A business owner says to you, as a creator, I want you to copy Apple's website and change the logo. Now that's a very different conversation. Or perhaps someone says, I love the look of this competitor's branding. Being inspired by the overall aesthetic may be fine. It may feel fine. Replicating the specific artwork, imagery, layouts, or design elements may not be. And if you want to look at how Audi gets away with it, go back and check out, I think it's episode 3 or 4. I'll put it in the show notes, which discusses the Audi situation. The distinction is subtle, but not critical. Copyright usually doesn't protect broad concepts. It protects the particular way those concepts are expressed. So what should businesses, creators, and entrepreneurs take away from the blurred lines case? Lesson number 1. Inspiration is normal. Every creator is influenced by others. That alone is not a problem. In fact, that's how creativity evolves. The question isn't whether inspiration exists. The question is what you do with it. The second lesson is to avoid direct replication. The more closely you reproduce specific creative elements, the greater the legal risk. Use references as a starting point rather than a blueprint. Lesson number 3. Create your own expression. Ask yourself, what am I adding? What am I changing? What makes this piece of work uniquely mine? The stronger your own contribution is, the safer your position usually becomes. Lesson number 4, document your creative process. For businesses working with designers, marketers, agencies, and content creators, keeping records can be invaluable. Sure, start with a Pinterest board and inspiration, but then show how these ideas evolved independently, because that can sometimes be the most important piece of evidence if a dispute arises later. Lesson number 5. Don't assume inspired by is a defense. Many infringement disputes begin with someone saying, "I wasn't copying, I was only inspired." And that may be true. But if the final result reproduces protected expression, that explanation may not solve the problem. The blurred lines case remains one of the most debated copyright decisions in modern history. Some see it as an important protection for original creators. Others see it as a warning about expanding copyright too far. Regardless of which side of the debate you sit on, the case highlights an issue every creator faces. How do you learn from what came before you without crossing the line into copying? The answer is that inspiration is not the enemy. In fact, inspiration is essential. But successful creators don't simply reproduce existing works. They transform it. They bring themselves to it, they build upon it, and they make something new. And that's often where the most valuable intellectual property is created. If you'd like help protecting the creative assets in your business, whether it's branding, copyright, trademarks, or considering your ownership structures, you can visit my website, www.elisesteegstra.com, to book a strategy call. And I'll see you in the next episode. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.